Morning, everybody.
Good morning, Lordship. Morning, Lordship.
Good morning. Yes.
On the heading for orders will depend. Item number 1, CMP number 310 is 2015 with the location of order.
This is for restoration of first appeal.
So remove the defects.
That's 2 weeks time.
ये हम लोग के पास आना चाहिए लिखा हुआ है चीफ रजिस्ट्रेशन दिया है वो उसके 2 weeks time to must look at then council for the office to place the file.
Item number 2, Government PS number 6124 2015 with the Arvind Kumar Chaudhary for the
Lord, in this case, I have already removed the defect. One defect with regard to certified copy, my lord. We have filed the fresh copy also, my lord. There is typing error in the impugn order, my lord, page 45 and 46, my lord. Paragraphing number जो है, so 7 के बाद page 45 में जो है 11 लिख दिया गया है. जबकि pagination is correct, my lord. 1, 2, 3, 4, 5. फ्रेश सर्टिफाइड कॉपी ऑब्टेन करके कल फिर डाल दिए हैं, वही चीज है एज इट इज.
Defect number 2 is impugned order may be affidavitted. Its pagination may be indicated by office OC on page 1. It may be given annexure numbers. Defect number
दैट impugned order में जो है वही
original copy of impugned order may be filed. That you have filed. Defect number 5 is from para number in page number 45 and 46. It appears that page number 45 are not in continuation. And 9 is copy served to learned counsel for respondent may be verified for retainer slip. So, which defect do you say that have been removed?
Milord, with regard to pagination, Milord, of page 45 and 46, Milord, that.
An original copy of impugned order that you have filed.
Yes. Again, fresh copy yesterday I have filed certified copy, Milord.
And impugned order may be affidavitted
That fresh supplementary affidavit I will file, Milord, with to that effect, Milord.
So, according to you, defect number 5 and 3 have been removed.
Yes. And all other defects has been removed, Milord. One copy has to be served to the retainer. We have served to M.A. Khan. Now the present, Milord, who is that? That we have to. Earlier M.A. Khan was the retainer, Milord.
Counsel for the petitioner, Mr. Arvind Kumar Chaudhary submits that original copy of the impugned order has been filed yesterday and thus defect number 3 stands removed. Stop. Further submits that defect number 5 these pages are in continuation 44, 45 and 46. Mr. Chaudhary, this defect number 5, you say that 45 and 46 are in continuation. Unmute yourself. 4, 5, ठीक है. Defect number 5 is ignored. Stop. And counsel for the petitioner further submits that supplementary affidavit would be filed to remove defect number 2. And copy of the pleadings would be served upon the present retainer's counsel and receipt thereof would be filed. Stop. For the removal of these 2 defects, 1 week time.
Milord, 2 weeks दे दिया जाए जो चूंकि एफिडेविट कराना पड़े.
2 weeks time is allowed.
Obliged, Milord.
Yes.
item 426 of 2018 with Akshay Kumar Mathur for the petition.
May I permitted to withdraw this application, madam?
This was for
I may
restoration.
permitted to withdraw this application, madam.
Okay. In counsel for the petitioner, Mr. Akshay Kumar Mathur seeks permission to withdraw this petition on instructions. Accordingly, petition is dismissed as withdrawn.
Item 4, CMP number 503 of Parliament, Mr. Pramod Kumar Jha for the petitioner.
May I please?
Yes,
4 weeks का टाइम दे दिया जाए जो डिफेक्ट फॉर डिफेक्ट्स इन
3 weeks time.
I am appearing for state blood SC to SC minus 1 blood.
Mr. Aishwarya Prakash, SC to SC Mines.
1.
Appearance here, 1. Let the name of SC Mines 1 appear in the cause list henceforth for the respondent state in place of the erstwhile counsel.
Yes.
4 weeks कर दिया था हुजूर
4 weeks.
Obliged.
Item number 5, condemn series 187 of 2019, Mr. Pramod Kumar, Mr. Akshay Kumar for the
Pray for 2 weeks time, Lord.
Pradeep Kumar Verma, learned counsel for petitioner, prays for is allowed 2 weeks time to remove the surviving defects as under office to place the file.
Item 6, CMP number 806 of 2019, Mr. Amit Sinha for the
Your Lordship, I pray for 2 week time to remove the surviving defects, Your Lordship.
Mr. Krishna Kumar, learned counsel for petitioner, prays for is allowed 2 weeks time. For same, Mr. Vijay, office to place the file.
Item 7, WPP number 3037 of 2021, Mr. Nitin Kumar Prasad for the petitioner, Mr. P.S. Pati for the respondent.
Look, so I'm seeking 3 weeks more time for these certified copies we have already applied for, but we have not yet received it from the concerned circle. In all possibility, within 3 weeks we'll receive it.
3 weeks time, more time is allowed. As prayed for to learn. As prayed for, 3 weeks more time is allowed to learn counsel for petitioner, Mr. Nitin Kumar Prasad to remove the surviving defects.
Much okay.
Place the file for the other side, Mr. P.S. Pati.
For order. Item number 8, WPS number 1720 of 2020, along with item number 9, Mr. Dev contract of the petitioner, Mr. Karthik for the
आज फादर में कुछ टाइपिंग एरर हो गया.
Yes, ma'am.
The matter has been placed on an office note as it appears that due to traffic, the number of the writ petition has inadvertently been wrongly typed in the previous order dated 14 February 2022. So in place of WPS number 1720 of 2017, the number of the writ petition should be read as WPS 1720 of 2017 instead of WPS number 1740 of 2017. Let the matter be listed as per the previous order.
Obliged.
Item 10, first appeal of 48 of 2021, Mr. Untitled Chapter for the appellant, Mr. P.S. Sinha for the
May I please, Your Lordship. In this matter, last occasion, respondent was noticed, Lordship. And as per the daily court list, the name of Neetu Sinha ma'am is appearing, Lordship. And she is representing the respondent in this matter.
Let the parties go for mediation.
Lordship, that will be best. But the Lordship, I have one request, Lordship. It may be in the mediation center of Papur because the
Girl resides at Paku, Lordship. It will be convenient for her.
The mediation must have had, no, earlier it was in Godda, so
Yes,
mediation
yes.
must have been held at Godda. Now at this appellate stage, let it be held at Jhalsa because
Yes, Lordship. It would be Lordship.
Lordship,
appellant will
maybe.
pay the cost.
Lordship.
Since may I humbly submit Lordship, since applicant had been working as a software engineer in USA Lordship, and nowadays he has left that job Lordship. He has been very much residing in India, and he is awaiting judgment in this matter Lordship. Finally to be decided by this honorable High Court.
Very well. You were asking
Facing
for
that final bench Lordship, so it not be able to like incur the expenses Lordship.
the boy was asking for restitution,
Yes,
but
Lordship.
this relief has not been allowed.
Lordship, vision had been assigned in that. It will not allow.
Respondent is concerned, she has been working as a teacher in Jawahar Navodaya Vidyalaya Lordship, and she has been fetching salary to the tune of 25,000 to 30,000 per month Lordship. So she's not like financially incapable
Boy
of
must be working somewhere. Lordship, he has left the service in USA.
job.
Are there any criminal cases?
No Lordship, no criminal case
No,
has been
Lordship.
registered.
No, Lordship. There is no criminal cases.
Then try and settle it through mediation at Jhalsa.
Lordship, that will be better.
Appellant
The respondent has entered appearance on notice through Wakalatnama. Stop. Mrs. Neetu Sinha appears for the respondent. Learned counsel for the parties agree that an effort for amicable settlement of the matrimonial dispute can be made through mediation, may be made through mediation at Jhalsa at this appellate stage also. The parties are willing to attend mediation physically at Jhalsa. Stop. In that view of the matter, let the parties approach the learning member secretary Jhalsa on 4th of March, so that in continuity 2-3 days mediation can be held, Saturday, Sunday. 4th of March 2020 at 10:30 a.m. The member secretary can also be approached as the following members. On their appearance, matter be placed before the learned mediator for undertaking the exercise. The parties are expected to
Lordship,
in
expenses may be given, Lordship, to the
jobless nowadays.
with an open mind and attend each of the sittings. Appellant shall pay a sum of rupees 2,000 to the respondent on each date she attends the mediation at Jhalsa in the presence of learned mediator Jhalsa. If both the parties are able, learned mediator would endeavor to conduct the mediation proceedings on initially learned mediator would endeavor to hold the mediation sittings on successive days, as the parties have to come from far off, and subsequent dates may be given as per the convenience of the parties. Stop. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. Matter be placed in the week of 18th April 2022 along with the report.
all like us.
Item number 11, number CP4 of 2018, Mr. Ramanama Polda.
Perhaps Honorable Mr. Justice Deepak Roshan, because this is a period of 2018, Malaj.
11, 12, 13, all 11, 12, 13 will let the matter be placed before a bench of which there is an order in fact. In view of the order dated pehle wale mein likhe 11, in view of the order dated 5th March 2020, office to place the file before the appropriate bench. Of 12, 13 May, let the matter be placed before a bench of which one of us, within bracket Deepak Roshan J, is not a member. देखो से should have seen it. हमारा नजर चल गया उसका. cover file to be provided. Yes.
Manoj, in the next serial number.
14 call करिए.
Item 43 number 58 of 2019, Mr. Rahul Lama of the appeal.
Manoj, I'm praying for 2 weeks' time to seek instruction with respect to withdrawal, Manoj.
Get a list in your office of those pending and admission cases.
Manoj.
As per your own.
Manoj, I'm working on that. Manoj, I'm working on that exercise. I'm collating all the tax appeals of 2019 and 20 at least where the tax effect is less, Manoj.
The only exception, which is the new exception in draft, is audit objection.
Manoj, actually there are six exceptions, Manoj.
Previously also.
Manoj, the additional, yes.
Send those notifications also.
Manoj, I'll send it today itself, Manoj. I'll send both the notifications. I'll send.
And counsel for the applicant, Mr. Rahul Lamba, pays for 2 weeks' time to seek instruction as to the tax effect of the disputed amount, with semicolon, whether it falls within the monetary limit for preferring the appeal before this court or is covered under any of the exceptions of the departmental notification.
Much obliged, Manoj.
Still after 2 weeks. Mr. Devesh Poddar for respondent.
No, sir.
17-18 pages of call.
Item 70, appeal number 23 of 2021, Mr. Rohit Agarwal of the appeal. Item 70.
This is here. On consent withdrawal. Yes, who appears for the appellant? In item 17, Mr. Arvind Kumar Chaudhary. Mr. Rohit Agarwal. Anyone appearing in item 17? 17 को pass over करते हैं for one case. Let's just take up item 18.
Item 18. Item number 2021, Mr. Mukesh Kumar Dubey for the appeal.
My lord, in item number 18.
Right. So, husband's for guardianship.
Guardianship, yes, my lord.
How old is the child?
Child is 8 years. The problem is the court had decided the custody of a child who is not child of this person. This is the problem.
Any matrimonial dispute earlier?
Yes, matrimonial dispute is there.
Pending.
Divorce case is Patna and the maintenance revision case is High Court Jharkhand.
So you deny that the child is born out of the wedlock or what?
No. The court has decided the custody of the child who is not my child. I have a child for which I am preferring custody case. But court has not decided the custody of that child. I have given my ground in ground 4 and 5 elaborately, my lord.
Jyotir Aditya Pandey, you were seeking custody.
Yes.
And the court has decided regarding whom? Who else?
Aditya Jyoti Pandey.
You were asking for the custody of that child only.
I am asking for Aditya Jyoti Pandey, my lord. The respondent is living last 2011 with me. I have one child with at that time. Now the custody of child has decided whose age is 2014 when I have a no marriage she is not living with me.
So the names are matching, or names are bit identical.
Yes.
Issue notice on the respondent and the registered cover with schedule, speed post, and it's a Ranchi only.
Yes.
An ordinary process for which requisites be filed within 1 week.
2 weeks, my lord.
2 weeks. Office to track speed post delivery. Yes, item 17. Anyone has appeared?
Yes, my lord, I am appearing, my lord, in this case. My lord, notice the first time it has come forward.
So, 13B consent withdrawn. What is your plea?
My lord, she has taken the entire money, as per the agreement, and thereafter withdraw from 13B application, my lord.
Issue notice on the respondent and the registered. Have you stated those grounds?
Yes, my lord, that is stated.
Issue notice on the respondent and the registered cover with it speed post and ordinary process for which requisites be filed within 1 week.
Yes, my lord.
Office to track speed post delivery. Yes. Now 15.
Item 15. WPT number 9.5 of 2020. Mr. P.S. for the petitioner. Mr.
Yes, who is appearing in item 15? Mr. Pati? Mr. Amit Kumar, you unmute yourself.
Lordship, in this case, Mr. Pati has filed this writ petition, Lordship, and thereafter he has assigned some other counsel to be, as he has been appointed as senior.
How after losing the tax appeal up to the High Court,
Yes, Lordship.
stage of recovery, the petitioner is asking don't give effect to the order in original.
Actually, Lordship, in some of the cases, other cases, like in Stan Commodities and Galaxy, Jagdamba, Indigo, and these cases, Lordship, they have these petitioners have directly come to this honorable court after show cause and order in original. In that cases, on the basis of RA casting of the honorable Supreme Court, Lordship, this honorable court has passed an order directing the respondent revenue to do a physical verification after going to the factories and doing the physical experiment.
That is a closed chapter so far as this petition is concerned.
Yes, Lordship. But in this case, they have traveled up to the tax appeal before this honorable court.
Of all the courts and subsequently they are asking that don't do. How it is possible?
But incidentally, brother will not hear it because the tax appeal he was appearing for respondent. Let the matter be placed before a bench of which one of us, Nico Crossan J, within bracket, is not a member.
Item 15. WPT number 347 of 2020. Mr. Kumar Prasad for the petitioner. Mr. Jharkhand.
Looks in this matter, we had.
Your Lordships, I was just praying for a short Passover. My senior had to assist Your Lordships, but she is engaged in another court at the moment.
So what?
बाकी दोनों फाइल निकाल
Item
19.
Item 19, notification number 1 is of 2021, along with chapter number 2021. Mr. Nidhi Kumar Kesari for this number, Satin Kumar, Mr. Kumar Yadav.
Look, in all these matters, a common issue which we have raised is with regard to the jurisdiction of the state tax officer in carrying out proceedings under section 129 when the transaction pertains to integrated goods and service tax. Secondly,
That they have answered by citing the notification whereby the central and state tax officers both have been given jurisdiction.
no, Milits, that there is a catch, Milits. If Milits would see section 20 of the IGST Act read with section 4 and 6, Milits, it says that it is the council which can issue a recommendation and on the basis of which the notification has to be issued. The notification which has been issued by the state government, not by the central government or the council.
That is not under challenge.
That is not under challenge, Milits. That was not required to be challenged, Milits. If Milits would, for a moment, look at the language which has been employed under the Act for a moment, Section 20 of the IGST Act.
There is a provision for appeal, so you better avail the appeal.
Milits, we tried, but we could not. Because, Milits, what happens is that in order to maintain an appeal, first of all, I have to have a registration and a password, ID and password. Suo motu registrations are being granted, but no ID password is being granted. So until and unless the ID password is there,
That Mr. Mittal will give an answer.
that apart, in all these cases, Section 129 says that there has to be an opportunity of hearing before imposition of penalty. Now, in order to get the trucks released, the vehicles released, we carried out a proceeding that we are ready to deposit under protest. But the moment we give the bank guarantee, they close the proceedings, saying that once you have deposited the bank guarantee or the money, there is no provision of under protest payment. Hence, the proceedings are closed in all these matters.
GST MOB 7 was issued and a personal hearing date was also given in the first matter.
But thereafter they have closed the proceedings. They have closed the proceedings.
They say that you have not participated, so they have passed the order.
Otherwise
All these points can be raised in before the appellate authority.
Let me satisfy on the issue. First of all, if my lords would see for a moment section 20 of the IGST Act. Milits have given a compilation. If Milits have the compilation.
Is there in your compilation also?
Yes, it's in my compilation also. Milits.
Page number?
Page 16. Page 16, Milits.
Yes.
May I place it, Milits?
Yes.
Section 20 of the Integrated Goods and Services Act 2017, subject to the provisions of this Act, the rules made thereunder, the provisions of Central Goods and Services Tax Act relating to such and such. Well, I am concerned with serial number 15, Roman 15.
Yes.
And thereafter shall mutatis mutandis apply so far as may be in relation to integrated tax as they apply in relation to central tax as if they are enacted under this Act.
Right.
And then let's may come for a moment to section 6. Unfortunately, section 6 is not there in this compilation. Sorry, section 4 of the IGST Act.
For that we'll have to go back to the book.
Yes, Manoj.
Page 543.
Section 4, Manoj. It's authorization of officers of state tax or union territory tax as proper officer in certain circumstances. Without prejudice to the provisions of this Act, the officers appointed under the State Goods and Services Tax Act or the Union Territory Goods and Services Tax Act are authorized to be the proper officers for the purposes of this Act, subject to such exceptions and conditions as the government shall, on the recommendations of the Council, by notification specify. Now, the notification which they have annexed to their counter affidavit
Right. Yes.
Now, if pilots would see the annexure which they have annexed to their counter affidavit, annexure A at page 9, pilots are taking up WPT 1823 minutes.
First item.
Yes, 1823. Annexure 9 at annexure A at page 9.
Yes.
May I place it, minutes?
Yes, yes.
In exercise of powers conferred by subsection 1 and subsection 2 of section 5, read with clause 91 of section 2 of the Jharkhand Goods and Services Tax Act and the rules framed thereunder, I do hereby assign the officers mentioned in column 4 of the table below the functions as the proper officers in relation to various sections of Jharkhand Goods and Services Tax Act or rules made thereunder, given in the corresponding entry in column 2 of the table. The functions hereby assigned to the specified authority in column 4 of the schedule shall be performed only within their jurisdiction unless specific jurisdiction is mentioned there against. Now, let the third page, at page 11, entry 37.
Yes.
Entry 37, the powers under section 129, 3 and 6, detention of goods and conveyances, state tax officer, assistant commissioner, state tax, deputy commissioner, state tax having jurisdiction. Now, this notification does not in any manner confer the power under the IGST Act because the notification has to come from the central government.
Annexure B.
Yes, my lord. Now, annexure B at page 13, if my lords would see paragraph 3.
Yes.
It is accordingly clarified that the officers of both central tax and state tax are authorized to initiate intelligence-based enforcement action on the entire taxpayer's base, irrespective of the administrative assignment of the taxpayer to any authority. The authority which initiates such action is empowered to complete the entire process of investigation, issuance of SCN, adjudication, recovery, filing of appeal, etc., arising out of such action. In other words, if an officer of the Central Tax Authority initiates intelligence-based enforcement action against a taxpayer administratively assigned to State Tax Authority, the officers of the Central Tax Authority would not transfer the said case to its state tax counterpart and would themselves take the case to its logical conclusion. So that this clarification does not in any manner authorize the state officer to initiate a proceeding under section 129.
Why?
Because if my lords, we see paragraph 3 last line, the authority which initiates such action, first of all, it is intelligence based enforcement. This detention of goods is a regular procedure. It's not an intelligence based enforcement, because no investigation as such is to be carried out. And when we say about investigation, then we have to go back to section 67, 70, 73, 74. That procedure, so far as 129 is concerned, is never there. Because 129, it is just whenever goods are in transit, they call for the documents, that if the documents are genuine or not, and the goods which is mentioned in the e-way bill, it is the same goods or it is not the same goods. That is all. Now, in my case, in these three cases, what has happened, there is no dispute with regard to me carrying the goods in terms of my invoice and in terms of e-way bill. All that is the allegation against me is that e-way bill having expired, there is an evasion of tax. In all these cases. Now, I have minutes in my... वो निकालो तो जिसमें वो रेलीगेट टीम किया है.
Mr. Mittal?
Only one thing, if I am allowed to say, let's subject to Maharaj's permission. Well, I have in my compilation annexed the purpose of introduction of e-way bill, the discussion which the CBIC had carried out. And if my lords would take up page 1 of the said compilation, the last
we have seen that.
So it categorically says that there has to be, the only purpose is there of evasion of tax. In these cases, there is no evasion. There is no evasion of tax. What has happened is, because of the reasons mentioned, well, the truck could not reach to its destination and the e-way bills had expired. So first of all,
it could have been revalidated.
It could have been. Now, in the third case, which I have filed, Rimjim Ispat, in that case, the truck was stranded in a secluded place where there was no internet connection.
All those things, the factual things, we can't look into whether there was.
So I understand that. But first of all, they have taken into consideration that expiry of way bill is an evasion of tax. So first of all, they have to satisfy that as to how expiry of e-way bill can be termed to be evasion of tax. Although
Section 129 and the requirement of carrying a goods in movement on the basis of an e-way bill has its own consequences.
Correct, Manoj. Absolutely correct, Manoj.
Not followed, then face the consequences. So every time for a lapse or expiry of an e-way bill, it is not required for the authority to see whether there was intention to evade tax.
Millards, that is what I wanted, Millards. If Millards would see for a moment section 122 of the CGST Act. And the other high courts have also interpreted the same very provisions, Millards. In fact, Millards, in one of the matters arising out of Telangana, Millards, the e-way bill had expired. The officer concerned had detained the goods for 2 weeks, and thereafter the Telangana High Court, Millards, quashed the entire proceedings, imposed a penalty of rupees 10,000. State of Telangana went to the Supreme Court, and recently the Supreme Court has rejected the appeal, taking note of the fact that expiry of e-way bill is no evasion. Because I have annexed that judgment in Rimjin's part and enhanced the cost upon the state from rupees 10,000 to rupees 69,000. The exact amount of penalty which the state wanted to impose for expiry of e-way bill. That order of Supreme Court, Millards, I have annexed, Millards, in Rimjin's Fat's rejoinder.
Section 129 starts with a non-obstante clause
Yes, Millards.
and says that if a person is transporting any goods and they are in transit in contravention of the provisions of the Act, then these consequences will follow.
Yes, Millards.
Where does it speak that it should be also a necessary requirement that the proper officer should come to a finding that there has resulted in evasion of tax?
Millards, that is what they are saying, that it's an evasion of tax. An expiry of e-way bill does not tantamount to evasion of tax, Millards. And all these are tax paid goods. The goods which were being transported are all tax paid from the destination where the goods were they started its transportation.
Why are the e-way bills then issued?
Millards, e-way bill is only for the purpose. That is why, Millards, I wanted to place the compilation that why is e-way bill issued, Millards. That is precisely the reason, Millards, because it has two ingredients. If I can place, if I am allowed, Millards. May I place, Millards, for once, Millards, page 1. It's a discussion on the e-way bill.
Yes.
Millards, the last page 1, last heading, e-way bill under GST.
Yes.
E-way bill is an electronic document generated on the GST portal evidencing movement of goods. It has two components. Part A, PIN code, invoice or challan, number and date, value of goods, HSN code, transport document, goods receipt number, railway receipt number, airway bill number or bill of lading number, and reasons for transportation. And part B comprising of transporter details, vehicle number. As per Rule 138 of the CGST rules, every registered person who causes movement of goods, which may not necessarily be on account of supply of consignment value more than rupees 50,000, is required to furnish above mentioned information in Part A of e-way bill. The Part B containing transport details helps in generation of e-way bill. E-way bill is to be generated by the consignor or consignee himself if the transportation is being done in own hired conveyance or by railways, by air or by vessel. If the goods are handed over to the transporter for transportation by road, e-way bill is to be generated by the transporter where neither the consignor nor the consignee generates the e-way bill and the value of goods is more than 50,000, it shall be the responsibility of the transporter to generate. In my case, we have generated. Further, it has been provided that where goods are said, no, this is not relevant. Now, I'm coming straightway to page 4, purpose of e-way bill.
Yes.
E-way bill is a mechanism to ensure that goods being transported comply with the GST law and is an effective tool to track movement of goods and check tax evasion.
Yes.
Then, Millards, I am coming to page 8, Millards.
6, maybe. There is always a possibility of multiple vehicles are used for carrying the same concern.
Let's page 8.
Yes.
Consequences of non-conformance to e-way bill rule. If e-way bills, wherever required, are not issued in accordance with the provisions contained in Rule 138 of the CGST rules, the same will be considered as contravention of rules. As per Section 122 of the CGST Act, a taxable person who transports any taxable goods without the cover of specified documents, e-way bill is one of the specified documents, shall be liable to a penalty of rupees 10,000 or tax sought to be evaded wherever applicable, whichever is greater. So, CBIC was also conscious of the fact that it is for the purpose of curtailing tax evasion. In my case, only merely because of the fact that the e-way bill had expired, the department came to a finding that there is evasion of tax. I understand there is a contravention in terms of Rule 129, Section 129, but that does not entail that 122 cannot be adhered to. In Section 122, there is a specific mention of this provision. And then page 11, the conclusion by the CBIC.
Yes.
One provision I wanted to show to my lords, Rule 138B. Of the CGST rules,
Yes, yes.
May I place it?
Yes.
The commission, this is with regard to verification of documents and conveyances.
It's 280.
May I place it?
Yes.
The commissioner or an officer empowered by him in this behalf may authorize the proper officer to intercept any conveyance to verify the e-way bill in physical or electronic form for all interstate and intrastate movement of goods. The commissioner shall get radio frequency identification device readers installed at places where the verification of movement of goods is required to be carried out, and verification of movement of vehicles shall be done through such device readers where the e-way bill has been mapped with the said device. The physical verification of conveyances shall be carried out by the proper officer as authorized by the commissioner or an officer empowered by him in this behalf, provided that on receipt of specific information on evasion of tax, physical verification of a specific conveyance can also be carried out by any other officer after obtaining necessary approval of the commissioner or an officer authorized by him in this behalf. Now, the only purpose of inserting this provision was to check tax evasion. Now, if a e-way bill has expired, if at all, that can be taken to be evasion of tax. That is precisely the reason I wanted to place a particular judgment of Telangana High Court that I have annexed to my compilation. Look at page 141. At page 141 minutes.
Yes.
This is the Telangana High Court judgment against which the state had gone in appeal before the Supreme Court, and they have lost it on same fact. May I please?
Para 48 is the conclusion.
Yes, my lords, paragraph 48 and 51, my lords. And then, if my lords would take up for a moment the rejoinder of third case, my lords, in which we have annexed the judgment of Supreme Court. Because by the time I had filed the compilation, the judgment had not come, my lords.
Third petition is
This is WPT 4574 of 2021.
rejoinder.
Yes, my lords.
Rejoinder is not on record in this.
My lords, I had mailed it also, my lords. On Monday itself, I had mailed it also.
Affidavit of state is of 18th February, but no
Yes, my lords,
rejoinder.
and we filed it on Monday, 21st, the reply.
Maybe, but it is not on record.
We have filed on 18th December, my lord.
No, third case, Mr. Sachin,
So in
the Honorable Court is saying about third case. The hard copy was dropped in the Dropbox.
You are relying upon the order of the apex court in which the special leave was dismissed and some cost was also enhanced.
Yes, my lords. And this judgment of Telangana High Court was upheld. Same issue, expiry of way bill, allegation of evasion of tax. Same issue. And minutes, only one paragraph, if I can read, of the Honorable Supreme Court judgment, where this has been taken into consideration that the matter arises out of expiry of e-way bill. In so many words, it has been said.
There is a lot of discussion on facts of that case in this Telangana judgment.
Yes, my lords.
In that case, my lord, because of traffic jam, perhaps, my lord, the vehicle could not reach rally, my lord, yes, could not reach the destination. So these are the factual aspects that are required to be pleaded and proved before the competent authority.
So how do they prefer an appeal? What is your answer to
My lord,
that?
we can take, though, my lord, they have got, my lord, temporary registration, but we can seek instruction on that part, my lord, how they can prefer. Because
the company wants to contest. The truck driver is not interested.
My lord.
Yes.
So how does
Company
the
is
company
affected, so he must have opportunity to file appeal.
Yes. My lord, once order is there, the opportunity must be there to file appeal. There is no denial of that, my lord. Appeal cannot be denied.
My lords, may I submit?
Yes, Mr. Mittal.
My lords, in serial number 21, my lords, which is the third case, my lords, the JCCT has written a letter to them that please file an appeal online. You cannot file it manually, and the reason they could not file it online, again they say that there's some problem on the portal by which they could not file it online. My lord, there are two things, my lord. GSTN is not a party which can either verify whether there's any difficulty in filing the appeal or not. The appellate authority is not a party. The letter dated 26/3/21 by which they have been directed to file an online copy, not a manual copy, has not been impugned. Because there is a clear forum available to them and they are aware of it, they approach the forum. And since there is some difficulty in going to that forum, they approach this writ court on, my lords, on a plea of without jurisdiction. Because if an appeal can be maintained, they've in fact made the pre-deposit also. So, my lords, if they add the STN as a party and the appellate authority as a party, and if it can go to the appellate authority, my lords, then the purpose would be solved.
What difficulties are they facing in preferring an appeal?
Now, I'll clarify, my lords. First of all, whenever there is an order passed, so far as the e-way bills are concerned, there is a number which is generated. And on the basis of that number, a temporary ID is created by the suo motu registration authority, the assessing authority. Now, this suo motu registration has to be coupled with the ID and the password. Suo motu registration is carried out by the authority, but neither the ID is created nor a password is created until and unless this ID and password is given to me. Manoj, I cannot prefer an appeal. Now, I being an
This
aggrieved authority.
is generated by the portal.
Yes, Manoj.
The ID and password, these things are generated by the GSTN portal.
No, Manoj, the assessing authority himself. Because what they are doing is they are giving suo motu registration to the truck drivers. Although the payments are being made by the either the purchaser or the seller. In all these cases, which I have annexed in my compilation.
Why is the assessing authority not issuing those two?
Let's say it is for the department to clarify that why they are not doing it that way. That apart, my learned friend Mr. Mittal has rightly pointed out that I have made a pre-deposit and I tried to file it online by using my ID password. But since there is a number which is generated and in that number my name is not reflected, it is the name of the truck driver which is reflected.
No, my lord.
It will not.
The truck driver's name is not reflected, my lord. It's Bhaskar Bajpai, who is the authorized representative. His name is reflected. The truck driver's name is not reflected.
No. You are not trying to understand, Mr. Mittal. There is a number which is generated while passing the order. Now, this number pertains to a proceedings under section 129 in which the assessee, the purchaser or seller is not a party. But who's a party? The truck driver. So the purchaser or seller cannot use their ID for entering into the GST portal. I think Mr. Garodia wants to clarify something.
My lord, it's not being done, my lord. The appeals under these kind of orders, we have also attempted an appeal, and the appeals are not being taken up. Where the company is not made.
Appeals are not being. It's not possible to file an appeal by the company in place of the truck driver, or
no.
It's not possible to file the appeal by the owner or the seller instead of the truck driver. And the order also, my lord, they issue only DRC 07, and thereafter they don't issue the consequential follow-up orders, which also has a number. They treat the proceedings as closed. Your lordships, my lord, something has to be administered to the state tax authorities. Central tax, this problem doesn't come. Even DRC 1, my lord, your lordship's judgment, NKS now is cited across the country. DRC 01, that it is that DRC 01 has to be issued. They have to give a proper show cause notice. And this problem, my lord, is there with respect to the appellate authorities filing an appeal against the truck seizure case, especially 129 matters. And because they realize the entire amount because of the truck has to be released. So they get satisfied with the entire penalty. And after that, it's like the SSE may run from pillar to post. This is actually happening.
And look, the other high courts have even taken the view that in these nature of matters, where the matter pertains to expiry of e-way bills, the courts have said that we will not relegate them to appellate authority. I have the order in hand. Unfortunately, I could not mail it yesterday. I got it just now. My sister just gave it to me.
Well, there are contrary orders also, my lords, of the Kerala High Court that expiry of e-way bill, my lord, the Gulzag principle would apply, that no mens rea is applicable.
I'm very sorry to say, Guljag Industries are on an absolutely different line. Please do not mingle up VAT and GST because VAT, there was a
principle is of mens rea, not of VAT.
Guljag Industries, Supreme Court has categorically said that we are confining it only in a case where manipulations have been done in the, transportation documents.
There are certain arbiter of the Honorable Supreme Court in Gulzag, and even arbiter would be binding on the Honorable High Court or the Supreme Court.
So I will not join issue on that.
Mr. Mittal and Mr. Sachin, you provide an answer as to how the company would be able to prefer an appeal.
Certainly, my lord.
We'll take instructions, my lord. Because, my lord, the temporary registration has been given to an authorized representative, my lord, and on his ID he has filed an appeal. My lord, it is to see whether the user ID and password is generated by the assessing officer itself or whether it is done by the portal. Because that appeal will have to be filed on the temporary ID because the DRC-7 is issued on that temporary ID.
And then it is not followed up.
Well, it's that why there is a difficulty in preferring an appeal, my lords, we'll take instructions, whether it is the problem in the portal or whether the state authorities are not generating ID passwords, my lord, we'll have to take instructions.
In all these petitions, on account of expiry of the e-way bill during transit of goods, proceedings have been initiated against the truck driver in all these three matters.
Yes, my lords. All these matters, truck drivers.
Under section 129 of the JGST,
Yes, my lords.
JGST Act. Stop. Proceedings have ended up in an order and issuance of a demand under DRC 07.
Not in all the matters, my lords. Not in all the matters. Only third matter, DRC 07 has been issued.
Orders have been passed. Proceedings have ended up in orders passed by the proper officer, imposing tax and penalty upon individual truck drivers.
Yes, ma'am.
Petitioners are the companies whose goods were in transit. They are not registered in. They are not registered person in the state of Jharkhand.
No.
But they have been issued temporary registration.
Let's the truck drivers have been issued registrations, not these people.
But the truck drivers have been issued temporary registration on which proceedings have been conducted.
Yes.
Stop. The company is facing the liability and wants to prefer an appeal. But it is precluded from preferring an appeal online because necessary password, ID, etc. are not being initiated as per the petitioners. Stop. Section 107 of the Act provides for appeal. Stop. Various questions of fact have been raised in the respective writ petitions. As such, this court at this stage considers it necessary to seek the response of the state as to how the petitioner companies could prefer an appeal being aggrieved by the liability created in a proceeding under section 129 against the truck drivers who were carrying the goods in transit. That will suffice, Mr. Sachin and Mr.
Yes, Miller.
Yes, ma'am.
How much time do you require?
2 weeks, Miller.
2 weeks.
We will file the.
Then on the next day, again, will you ask GSTN to be implemented as party?
Well, that depends on the reply that is given by the state authorities, whether
we will seek instruction, Miller, and whatever will be the.
Then if you pass on the buck, then we will implement the GSTN today itself.
If there is any practical difficulty in Millard to that extent, then GSTN will be a necessary party, Millard, for that purpose.
Any of the councils of CGST are appearing? Mr. Pati or Mr. Amit Kumar?
I can ask Mr. Pati Millard to join.
Mr. Pati?
May I ask Millard him to join?
Ask him to join.
My lord. He is joining, my lord.
Yes, Mr. Pati. Unmute.
My lord, item 24 has been called off, my lord.
No, you are not in these items, these three.
19, 20, 21.
But an issue is arising on the question of filing of appeal by a company whose goods have been detained because of expiry of e-way bill and proceedings initiated against the truck driver only. The company is facing difficulty in preferring an appeal under section 107, saying that user ID, password, etc. is not being generated. The temporary registration has been issued in the name of the truck driver, who is not interested. So, what is the mechanism in the GSTN network to take care of such a situation? For that, we need to be enlightened by your assistance.
My lord, I will take instruction, my lord. I'll require some time in that case, my lord.
Do you need to be implemented also in these?
Yes, my lord. Yes, my lord. Kindly, that will help us, my lord, in filing the response.
But don't take a long time, because otherwise the pleadings are complete.
But 3 weeks kindly permitted, because I have to take instruction from the Delhi office. GSTN office is at Delhi, located in New Delhi.
We deem it necessary to implement the GSTN through whom?
But I'll give the details, my lord, complete details to the court master, my lord.
For the proper answer to this legal issue. Stop. Mr. P.S. Pati, let such implementation be carried out by learned counsel for the parties by Friday. Stop. Mr. P.S. Pati, who appears for CGST, accepts notice on behalf of the GSTN and is allowed 3 weeks time to obtain instruction and file a response. Stop. Pleadings be supplied
by tomorrow.
To Mr. Pati. Stop. Then counsel for the state would also seek instruction from their end. Let the matter appear on today's 23rd. March.
Yes, Manoj.
14th March.
The petitions in all the three matters should be given, or just in first case, Manoj?
No, give him in all the matters.
Fair enough. We'll give it.
Mr. Mittal and Mr. Sachin, you also seek an answer on the jurisdictional question about the state tax authority initiating the proceeding.
That we have replied, my lord, in the counter, but we will again, my lord, get.
Yes. Yes. There's a judgment also, my lord, to the Madhya Pradesh High Court on the same issue, my lord, that I had supplied.
On that you have sent.
Section 4, Section 6, my lord, of the IST and CGST, that is clear, my lord. Read with the provisions of the JGST.
Advantage India Logistics Private Limited.
Yes, my lord.
Very well.
Yes.
Let the name of Mr. P.S. Pati appear in the court.
Yes, obliged.
Item 22, subcommittee number 2508, along with item number 23.
Just may I kindly take up item number 23, 4509, my lord. same, but that's for the earlier year. Milord, before going on to the facts, Milord, may I just explain the issue, which is very, very narrow, and the learned tribunal has completely erred, though they have noticed this honorable court's judgment.
There is no counter affidavit required.
My lord, I would be praying for an interim stay for a reason, my lord, if your lordships may see section 42 for a moment. My lord, this issue is a settled issue which is sought to be re-agitated, and because of the order of the tribunal, my lord, may kindly see section 42 of the JVAT Act. And they have, because of this, my lord, the entire state, my lord, there would be an anarchy with respect to the ITC on intrastate stock transfer, since the tribunal's judgment has come.
Anarchy exists for so many other reasons.
Of course, my lord, if your lordships may just, I'll have to prima facie convince your lordships that the tribunal proceeded on a complete erroneous basis. My lord, section 42, subsection 2.
Yes.
Where any court or tribunal passes an order in appeal or revision to the effect that any tax assessed under this act or the Central Sales Tax Act should have been assessed under the provisions of the law other than that under which it was assessed, then in consequence of such order or to give effect to any finding or direction contained in such order, such turnover and part thereof may be assessed or reassessed as the case may be to a tax at any time within 2 years from the date of such order, notwithstanding any limitation period which would otherwise be applicable to the assessment or reassessment. This is 1, my lord, and 42(1), my lord, if your lordships may see. Where any order passed by the prescribed authority in respect of a dealer for any period is found to be erroneous or prejudicial to the interest of revenue consequent to or in the light of any judgment or order of any court or tribunal which has become final, then notwithstanding anything contained in this act, the prescribed authority may proceed to reassess the tax payable by the dealer in accordance with such judgment or order at any time within a period of 3 years from the date of the judgment and order. So the effect of the judgment and the order of the tribunal now is that, my lord, that the entire assessments across the country, across the state, with respect to intra-state stock transfer is jeopardized. And, my lord, I have to show to your lordship the very basic principle. And they have started this also because of this judgment. But, my lord, I'll take your lordship only 5 minutes to make your lordship understand what is intrastate stock transfer and what was the intention of the legislature. Now, my lord, section 1843.
Let us go through the relevant section first.
Yes, my lord, it's all in my brief. If your lordships may take page 14 for a moment. I have quoted, or I can take it from the book, my lord, if your lordship wants to take with the book. Book would be convenient, my lord, but there is an unamended and amended provision.
Yes, yes.
So, your lordships are with the brief or with the book, my lord?
With the book.
With the book. Then, my lord, may kindly come to, my lord, section 18.
Unamended.
It's unamended.
इसकी कॉपी में So,
in fact, my lord, there is a detailed judgment of this honorable court, my lord, authored by Justice Deepak Roshan, my lord, which I will show subsequently, my lord.
let us go to your notes then, because the book with brother is the older edition.
In fact, my lord, if your lordships may take the brief, I will show the 3 provisions. Which are in the brief, my lord, at page 14. This is the first provision, my lord. These are the only three provisions involved, my lord. Page 14 first.
Yes.
My lord, it is input tax credit shall be allowed, CST Act, shall be allowed on purchase of goods made within the state of Jharkhand from a registered dealer holding a valid certificate of registration and which are intended for the purposes of, my lord, may kindly mark the word intended for the purposes of use as raw material for direct use in manufacturing or processing of goods for sale. My lord, since I am a manufacturing dealer, I am stopping here itself. So, my lord, there are three conditions for availing an input tax credit: that the goods have to be purchased within the state of Jharkhand. Second, it has to be purchased from a registered dealer. And third, so far as a manufacturing dealer is concerned, it is to be intended for use in manufacturing and processing of goods, and such manufactured goods are intended for sale. Now, my lord, this provision of the JVAT Act is not the first provision, my lord. It's in fact a provision which is continuing from the year 1956. If your lordship should just see, this is the first provision. I'll just come to later on the 1956 provision.
So you kindly repeat the argument just now you have completed about the ingredients.
The three ingredients, my lord, to avail the ITC is that I
Yes.
have to purchase the goods from within the state of Jharkhand.
Yes.
I have to purchase it from a registered dealer of the state of Jharkhand.
Yes.
And third is that the goods which I purchase is intended for the purpose of manufacturing and processing of goods for sale.
Well.
These are the three conditions, my lord. In fact, if your lordships, my lord, since your lordships are noting these three conditions, in my note, there is a division bench judgment, my lord, which specifically notices these three conditions and enumerates it at page 25 of my note, just to show that this division bench had considered the three conditions. Page 25, para 28, I'll just read it, my lord.
Yes.
For the purpose of adjudication of the dispute pertaining to issue number 1, provisions of section 1843 of the JVAT Act is relevant. A bare reading of the provisions of section 1843 of the JVAT Act, it would be evident that the following conditions are required to be complied with by a dealer in order to avail input tax credit on raw materials used by it in the manufacture and or processing of goods for sale, namely, purchase of goods should be made within the state of Jharkhand. Roman 2, purchase should be made from registered dealer holding valid certificate of registration. And Roman 3, goods purchased should be intended for the purpose of use as raw material for direct use in manufacturing or processing of goods for sale. Now, my lord, these are the three conditions. Now, my lord, there is no dispute in the three conditions. Now, my lord, the word for sale, which is there in the third condition, my lord, that the manufactured goods should be intended for sale. Now, my lord, in this, your lordships may just for a moment, my lord, take in this compilation itself at page 13. This exact similar provisions are there under the CST Act, right from the beginning of 1956, that if you purchase goods which are used for manufacturing and processing for sale. Now, my lord, this matter came up page 13, if your lordships may see. I am just trying to give, my lord, how the tribunal made a error, clear error. Tribunal noticed that the provisions have been amended, but then the tribunal made a clear error. Page 13, my lord, it's subsection 3 in the center. The goods referred to in clause B of subsection 1, we are concerned with B, are goods of a class or classes specified in the certificate of registration of the registered dealer purchasing the goods as being intended for resale by him. Page 13 of my compilation, my lord, center.
Center.
The goods, where it is mentioned, subsection 3 is quoted.
Yes, yes.
The goods referred to in clause B of subsection 1 are goods of class or classes specified in the certificate of registration of the registered dealer purchasing the goods as being intended for resale by him or subject to any rules made by the central government in this behalf for use by him in the manufacture or processing of goods for sale. These precise words were being interpreted by the Honorable Supreme Court under the CST Act. And my lord, the question was whether the sale has to be made by the dealer himself or it can be made by any other dealer on whether it is done on job work, whether it is by way of stock transfer. Then your lordship held, my lord, at paragraph next page 15, my lord.
Yes.
Now, here we find that the expression used by the legislature and also the rule-making authority is simpliciter for use in the manufacture of goods for sale without any addition of the words indicating that the sale must be by any particular individual. The legislature has designately abstained from using any words of limitation indicating that the sale should be by the registered dealer manufacturing goods. It is significant to note that where the legislature wanted to restrict the sale to any one by the registered dealer himself, the legislature used the qualifying words by him. This is also in our case, I will show section 1843. After the words for resale, in the first subclause of section 83B, indicating clearly that resale contemplated by that provision is resale by the registered dealer purchasing the goods and by no one else. But while enacting the second subclause of section 83B, the legislature did not qualify the words for sale by adding the words by him. This deliberate omission of the word by him after the words for sale clearly indicates that the legislature did not intend that the sale of manufactured goods should be restricted to the registered dealer manufacturing the goods. If the legislature intended that the sale of the manufactured goods should be by the registered dealer manufacturing the goods and by no one else, there is no reason why the words by him should have been omitted after the words for sale when the legislature considered it necessary to introduce those words after the words for resale in the first subclause of section 83B. The omission of the words by him is clearly deliberate and intentional, and it cannot be explained away on any reasonable hypothesis except that the legislature did not intend that the sale should be limited to that by the registered dealer manufacturing the goods. The court must construe the language of section 83B according to its plain words, and it cannot write in the section words which are not there. So, Malad, this is the interpretation of the words for use and for manufacturing for sale. And Malad, with this background,
So please cite illustrations to make clear the difference that would entail if one and the other interpretations are given effect to.
Yes. Now, Malad, the interpretation which is to be given, Malad, sale takes place in four manners, four modes of sale is there. Malad, the first sale which takes place is I am a manufacturer of the goods. I sell the goods to my dealers, to my customers from within the state itself, from my factory premises. That is called the sale by me as an intra-state sale within the state. The second sale is, my lord, I sell the goods myself outside the state by way of movement which has occasioned from my factory premises itself. It is called interstate sales. Third is, my lord, export sales, which I do again from my end. Now, the fourth sale, which is the bone of contention here, is that, my lord, I have a factory at Jamshedpur, I have another unit at Jamshedpur, and I may have a stockyard at Ranchi, or I may have a stockyard at Calcutta. Now, when I manufacture the goods, I am not selling the manufactured goods myself, but I am sending it to my another unit, or I am sending it to my stockyard at Ranchi, or I am sending it to my stockyard at Kolkata. So, my lord, if I send it to my stockyard at Ranchi or my another unit, then it is intra-state stock transfer. And when I am sending it to outside the state, it is interstate stock transfer. Now, my lord, the legislature in this case, when I show the amended and the original provisions, my lord, the restriction was only for sale. For sale included all these four kinds of sale. So even if I made stock transfer from outside, from my unit to Calcutta, then also I was entitled to ITC under the provisions of section 1843. But, my lord, the legislature in this case thought that if you stock transfer the finished goods outside the state to Calcutta, then you get the entire ITC, but the state may not get any tax when the goods are going to Calcutta and sold in Calcutta. So, my lord, the original provision said, I'll show, my lord, when I show that you will get ITC if you stock transfer to Calcutta only to the extent of the tax paid on the inputs in excess of 4 or 5%. That means they were retaining denying the input to the extent of 4%, and subsequently it was made 5% by saying that they are not losing the benefit of the tax. So if you have paid anything on inputs above 5%, you can claim that. But up to 5%, we will be retaining the benefit. We will not give you input tax credit. Now, what error, my lord, the legislature did when they enacted the original act, this restriction which they were imposing of giving the benefit of ITC above 4%, they imposed this restriction to both kind of stock transfers, that is stock transfer within the state also and stock transfer outside the state also. And because of the reason, my lord, in the original act which was there, even if I transferred the goods to my other unit from where it was sold, which was in Jharkhand, I was only getting ITC of above 4% and not beyond that. Now, my lord, several organizations represented that this is absolutely arbitrary, because ultimately the state of Jharkhand will be getting the tax in Jharkhand if my unit sells the goods in Jharkhand. So why are you putting this restriction? This restriction should have been confined only to a restriction from outside the state, when you can legitimately say that you will not get any tax on the sale outside the state because it goes to Calcutta and then Calcutta will get the VAT. So why are you putting this restriction so far as within the state is concerned? In that background, my lord, the legislature amended the provisions. And with this background, my lord, kindly see both the original and the amended provisions. It's in my note also, but it's in my book also. In the writ petition, page 19, my lord, if your lordship may see. Section 18.8 was the restriction, my lord. No input tax credit under subsection 1 shall be claimed or allowed to a registered dealer. We are concerned with Roman 9. In respect of goods used for manufacture of goods for transfer of stock, my lord. The word is transfer of stock. Kindly mark this words, my lord, because it includes both inter and intrastate transfer of stock, or other than by way of sale or sale outside the state of Jharkhand. And the proviso which was also there even then provided that in respect of transactions falling under this clause, input tax credit may be allowed on the tax paid in excess of 4% on such materials used in the manufacture of finished goods. So, my lord, here the words used were transfer of stock. So, this provision was causing hindrance even to intrastate stock transfer within the state. And you were only getting ITC above 4%, not beyond that. Now, my lord, kindly see the amended provision starts at page 20 from the bottom. No input tax credit under subsection 1 shall be claimed or be allowed to a registered dealer. We are concerned with Roman 9, my lord. In respect of goods consumed for manufacture of goods for interstate transfer of stock. So the word transfer of stock was qualified with the word interstate transfer of stock or for sale outside the state, provided that in respect of transactions falling under this clause, input tax credit may be allowed on the tax paid in excess of 4% of the finished good. Even in interstate, they are giving it in excess of 4%, my lord. Now, my lord, this word which was substituted interstate is retrospective substitution with effect from the date when the VAT Act came into existence, that is 1/4/2006. There is no dispute on that. Now, my lord, the whole genesis of the present case, how it got initiated was, there is a division bench judgment of our Honorable High Court of the year 2008, when this provision was not amended. And my lord, Tata Steel claimed that it had its mining unit at Noamundi, and they used the raw materials in that mining unit for doing the mining activity, and they stock transfer the finished goods, the mined products to Jamshedpur, which is ultimately used for manufacturing process. And they said that they were denied ITC on the basis of the unamended provision in only to the extent of 4% they were getting. So they filed a writ petition, my lord, in this High Court directly, and that order is at page 63. And your lordships in that matter at para 8 at page 66. This order is dated 24th April 2008 and
Yes.
page 66, my lord, I'll just read para 8.
Yes.
In the facts and circumstances of this case, writ petition filed by the petitioner unit at Jamshedpur, claiming relief in respect of mining activities at Normanda having separate registration is not maintainable. Jamshedpur was espousing the cause, so your lordship said. Besides that, on merits also, the petitioner is not entitled in any relief under section 1889 of the JVAT Act, which was the unamended JVAT Act 1889. Now, my lord, in my case, the assessing officer initiated proceedings and passed assessment order by relying upon this judgment of Tata Steel. By saying that you are not entitled, we brought to the assessing officer's notice that this provision has been amended with retrospective effect. Well, I may just indicate Tata Steel judgment, the SLP is admitted for hearing. I am engaged in that matter. We will be withdrawing it in view of the subsequent development, subject to the remand by the Supreme Court. But this, on this basis, my lord, the assessing authority and the appellate authority proceeded. To that extent, my lord, I am not joining issues because the tribunal said, no, it's wrong. The tribunal understood the issue that no, 1889, you are entitled, it has been amended. But what the tribunal made a grave error, my lord, is at page 126, if your lordships may come. The tribunal noticed the East India Cotton judgment. Tribunal noticed the judgment of this Honorable Court in Brahmaputra Metallics, where your lordship said that output tax liability is not the liability, it should not always be the consideration for the input tax if the statute provides. But then what the tribunal says, that you kindly come to page 126, my lord.
Yes.
Para 12 onwards, may I just read it, my lord?
Yes.
With this factual parameters, the issue raised and stated above is required to be considered by this tribunal. Apparently, in order to claim input tax credit, petitioner is bound to establish a case that he is covered in any of the subsections of section 18 and is not present in the negative list contained in section 18.8 of the JVAT Act. Intrastate stock transfer does not appear in section 18.8.9. The tribunal agrees. But merely because of the reason that it does not appear in section 18.8.9 does not make it eligible for a claim of input tax credit. Learned counsel in course of hearing has stated that the case of the petitioner comes under section 18.4.3 of the JVAT Act. On considering the statutory mandate and also the case laws referred to by the advocate of the petitioner, it is not in dispute that raw materials which may not be directly generating output are still to be considered eligible for input tax credit if essentially used in the manufacturing of the goods. The case law referred by the petitioner reported in 1981, which I just read for your lordships, clarifies that the definition of the term for sale, which includes intended for sale, not only by the registered dealer but by anyone else. Thus, these aspects of the law is not in dispute. the goods which are alleged to be used as raw material in the manufacturing of the final product will be entitled for input tax credit, but when? Well, this is where the tribunal makes an error. But when? What will be the stage for allowing input tax credit has to be considered. Whether stock transfer of such goods is eligible for input tax credit or not, particularly if such goods are subjected to intrastate stock transfer, is the point for consideration. Now, my lord, I just stop here itself. Once the tribunal says under 1843 I am entitled, once the tribunal says section 1889 intrastate stock transfer is not there, now, my lord, the tribunal is now posing itself a wrong question and answering it wrongly by saying, my lord, I'll read it further. It says, आप तो इंट्रास्टेट स्टॉक ट्रांसफर कर दिए तो आपको क्यों मिलेगा? अब जो जिसको जिस जगह भेजे हैं जिस यूनिट को वो क्लेम करेगा. How will he claim? It is my inputs on my manufacturing unit. I'll just read it further. The whole purpose of the taxation law intends to ensure that the state is not deprived of its taxation rights and the consumer is not overburdened by paying double taxes, and therefore VAT law was brought into force. When intrastate transfer of stock is made, practically there is no sale. This is again an error, my lord. Practically there is no sale. It is a sale by a subsequent person, and such goods may be used as raw material or consumed as raw material in course of manufacturing of finished product, but only at the time of sale of finished final product, taxes paid on such goods can be claimed as input tax credit. This is the error, my lord. An exception was carved out in terms of section 1889 where the interstate stock transfer was held to be ineligible for input tax credit, subject to the proviso that if tax is paid in excess of 4%, such ITC can be claimed. A composite reading of the proviso of section 1889 of the JVAT Act clearly shows that where stock transfer of goods are made from state of Jharkhand to any other state, that in terms of the proviso, the interest of the state is protected and the consumer is not overloaded with excessive tax, and therefore proportionate input tax credit is allowed on interstate stock transfer of goods or interstate sale of goods. This is not applicable when there is an intrastate transfer of stock. In case of intrastate transfer of stock, if input tax credit is claimed and if input tax credit is allowed, then the other unit of the petitioner will be at full liberty to subsequently make an interstate transfer of stock with no requirement to claim input tax credit, as he has already availed the same through Unit 2, which would be undoing the mandate of section 1889 of the JVAT Act. This is where the complete error, my lord. To the considered view of this tribunal, such allowing of ITC on intrastate transfer of stock would defeat the legislative purpose in protecting the interest of the state in recovering taxes. Further, there is nothing on, well, this is a perverse finding which I will show from the assessment order, nothing on record to show that subsequent to intrastate transfer of stock, the goods were to be consumed for manufacturing purposes or were sold within the state of Jharkhand. The rider contained in 1843 very categorically binds such transfer of goods for the purpose of manufacturing by requiring the dealer to sell such goods within the state of Jharkhand. Nothing, this is also sell such goods within the state, there is no finding. So this is where, my lord, the tribunal now says, my lord, now kindly see the anomaly. When I am sending my goods outside the state, the tribunal says you will get above 4%, you will get the ITC benefit. But if you are transferring it within the state, you will not get any ITC. My lord, the state which is getting
the tribunal's understanding is that so long you do not show that the sale is within the state of Jharkhand, the rider of 1889 will operate against you.
But that is the point, my lord.
Not only on stock transfer, but ultimately you have to show that the sale is within the state of Jharkhand to take the ITC.
That is not the mandate of section 1843, my lord. Otherwise, my lord, the stock transfer of the goods which is being done outside the state, those goods are sold outside the state only. I am not even claiming in those cases that I am selling it within the state of Jharkhand. This restriction of sale within the state of Jharkhand is not there. even in respect of intrastate stock transfer or interstate stock transfer. Otherwise, there was no occasion to prescribe ITC above 4% in the proviso. And because, and my lord, this view of the tribunal, my lord, consistent view of the department is, my lord, may kindly see annexure 11. I have just annexed one order. The department at no point of time has been disputing intrastate stock transfer. Kindly see page 135, my lord. The amended and unamended sections caused some problem. But page 135, I am just showing one of the submissions. The learned advocate of the petitioner has further submitted that the government of Jharkhand states that this amendment in section 1889 shall be deemed to come into force from 1/4. It has also been submitted that the learned assessing officer has calculated eligible ITC both on interstate stock transfer and intrastate stock transfer, and the learned appellate authority has confirmed the same by quoting the judgment of the Honorable Jharkhand High Court in Tata Steel Limited. It has been further submitted that the said judgment of Honorable Jharkhand High Court was made on the basis of section 1889, which originally stated from the language of original section. It was clearly stated in the section that in respect of goods consumed for manufacturing of goods for interstate transfer of stock or other for sale outside the state. That section 1889 is clear that section 1889 is applicable for both stock transfer within the state and stock transfer outside the state. Learned advocate for the, I skip all this, my lord. Then, my lord, kindly see the finding. At page 139. Peruse the revision petition, appellate order, assessment order, department amendment and notification as aforesaid. Submissions and contention of the learned advocate of the petitioner as well as the submissions of the departmental representative. In view of the aforesaid facts and circumstances, this court is of the view that the matter needs thorough examination and verification regarding issues of calculation of eligible ITC on stock transfer and disallowance of claim of ITC on consumables by the, as the said order has not been passed in accordance with law. So this is how it was remanded, my lord, and the order I have given on remand at page 142. ITC on stock transfer, my lord, was never being denied on intrastate stock transfer, and the proportionate calculation was always on interstate stock transfer. Page 142, my lord, if your lordships may see. At page 143 is relevant, my lord. This was the denial of 18 lakh input tax credit. At page 143, मूल आदेश में स्पेयर पार्ट्स की बिक्री के लिए इनपुट टैक्स क्रेडिट रुपीज इतना के दावे को स्वीकृत किए जाने माननीय वाणिज्य कर आयुक्त झारखंड रांची के द्वारा निर्देशित किया गया है. In view of the aforesaid fact, this court is of the view that the matter needs thorough examination and verification regarding issues of calculation of eligible ITC on stock transfer under section 1889 of the JVAT Act. इस संबंध में पूछे जाने पर उपस्थित प्रतिनिधि ने बताया कि वास्तव में झारखंड मूल्यवर्ग अधिनियम की 18(3) में स्पष्ट किया गया है कि सब्जेक्ट टू सच कंडीशंस एंड रेस्ट्रिक्शंस दैट partial and proportionate input tax credit may be allowed in such cases as may be used or consumed for their respective uses. ये भी बताया गया. But I am skipping all this. It is allowed on stock transfer and it has been continuously being allowed on stock transfer across the board. My pleading is specific to that effect in my writ application. So, the tribunal is in clear error, my lord, and I request your lordship, my lord, that this judgment may be stayed during the pendency of the application. I may indicate, my lord, I have paid the entire amount so far as the differential tax is concerned. But this judgment will have a very wide connotation and impact. We are in 5 years after GST, but this will reopen issues under VAT Act. para 47 of my writ, my lord, if your lordships may see.
Yes.
That at this stage it is most humbly stated and submitted that benefit of ITC on intrastate stock transfer pursuant to amendment carried has been set at rest, and the respondent authorities are regularly allowing the benefit of ITC on stock transfer to all registered dealers of the state of Jharkhand, including dealers like Tata Steel, Tata Motors, Usha Martin, etc.
Where are the state councils?
My lords, in serial number 22, we are appearing, Lordship, Mr. Sachin Kumar.
He was there at the time of the beginning of the arguments, and in between, why has he left without leave of the court?
My lords, we'll just check, Lordship. My lords.
He is obviously not there attending to the proceedings of this case. This is not proper. Time and again, it has been told that when counsels are attending a particular case, they should not put off the screen and skip to another court and then join back. Otherwise, how will be a continuity of the proceedings in one court?
And I'm sorry, my lords, I'll just check, Lordship. He's somewhere else, my lords. He's not here with me, my lords. I'll just check, Lordship.
And Mr. Sarona Mittal or Mr. Yadav?
Lords, I am appearing in cell number 23, Lordship.
23 for PA1.
Lords. The counter affidavit has been filed yesterday, Lordship, in serial number 23.
We have also filed a counter, my lords, in serial number 22. Also, we have filed a counter, Lordship.
None of your counters are on record.
It has been filed yesterday, my lords. That's why I meant.
Yes, Lordship. This has been filed yesterday only, Lordship.
Mr. Garodia, you wanted to show from the assessment order that it is nobody's case that particular observation as perverse you wanted to show. And in the
Yes.
assessment order.
Yes, I'll just show that. No, there is no finding that the goods are not sold. Annexure 2, page 57 is the assessment order.
Yes.
Page 60, if your lordships may see.
Yes.
स्वीकृत आईटीसी की गणना निम्नवत है। व्यवसायी कंपनी द्वारा इस अवधि में राज्य अंतर्गत भंडार अंतरण 12 करोड़ इतना का किया गया है, जो सकल अवर्ता का 14.88% है। अतः माननीय झारखंड उच्च न्यायालय के न्याय निर्णय में मेसर्स टाटा स्टील लिमिटेड बनाम स्टेट ऑफ झारखंड के मामले में दिनांक 24/4/2008 को जो न्याय निर्णय दिया गया है, उस मामले में भी अक्षरशः लागू होगा, क्योंकि इस कंपनी के द्वारा भी प्रांत के अंतर्गत स्टॉक ट्रांसफर किया गया है। अतः उच्च न्यायालय के आलोक में इस अनुपात में आईटीसी राशि अस्वीकृत बस।
So he doesn't take off the amended provision.
No, he doesn't take off the. That's what, my lord. He proceeded on Tata Steel. The appellate court proceeded on Tata Steel, and then, my lord, there is no dispute. My both units are in this. In fact, I would have. It was an ill advice at one point of time that the units were separated by a road, that they got 2 registrations.
Mr. Garodia, is there any requirement under the relevant provisions under section 18 that for not being denied the ITC as per the negative conditions under 18.8, it is also necessary for an SSC to show that after the stock transfer intrastate, the sale was also intrastate.
No, my lord, there is no requirement in section 18.8. That is where, my lord, the word for sale.
There is the guarantee that it won't be sold interstate after that stock transfer.
But if I sell it even interstate, even after stock transfer with the tribunal has said, then, my lord, so it is a sale.
No, that is true. So far as intrastate sale is concerned, it is within the state. But interstate sale, if the other unit sells it as an interstate sale, then the state of Jharkhand would be denied the tax despite you being allowed to avail the ITC.
No, my lord. Even if it is interstate sales, then CST, which will be levied, my lord, at the relevant point of time, it will come to the state of Jharkhand itself, my lord. The CST, the interstate, when it starts from the state of Jharkhand, then CST will be coming to the state of Jharkhand on those goods. But if this analogy is which the tribunal has applied, then, my lord, the entire purpose and the scheme of the act changes. Then I can't claim ITC at all at any stage of time.
Neither for interstate stock transfer nor for intrastate stock
Yes,
transfer.
for interstate and intrastate, both I can't claim ITC.
State councils are not there.
And, my lord,
You have
even at the
another
appellate stage order,
batch
if your
of
lordships may see, the appellate authority said I fall under 1843, but I just don't, I can't even conceive his reasoning, which he has given, page 82.
These other three writ petitions are now pending for hearing and exception.
Yes, now, my lord, my request would be subject to your lordships, my lord. I would have been otherwise not pestering your lordship on the stay of the impugned judgment, but for section 42(1), my lord, I was insisting. So if your lordships may stay the impugned judgment, fix any date, I'll file my written submissions, and it's a pure legal issue, my lord, which is to be answered and tagged along with the writ petitions. In those writ petitions, my lord, I came against the assessment order where your lordships admitted it.
Okay. You can counterfeit. We will not get any assistance from the state, Ms. Surabhi.
My lords, definitely, my lords will get assistance, lordship.
We will keep waiting for
No, lordship, I'm very sorry, my lords.
you. Both the state councils, those GA1 or AG2, AG2 could have made an arrangement that at least one of them is there. You are not able to assist us. What is your answer to this legal argument?
My lords, I'm just checking on him, my lords. We are not able to connect him, lordship. Same lordship.
Lords, my senior is Lex in court number 1, you lordship, therefore.
Tuesday the 15th. Last day. The second one, the first one is for which 2011-12. This is for 10-11. WPT number 4508 of 2021. Third Land Council for the petition.
My lord, there is some connectivity issue from my side, my lord. I am trying to connect from another.
But you were all along absent, and we were hearing the case as if you were also
Lord,
attending.
my connection got disrupted, my lord. I was trying to connect from mobile, my lord. I have connected.
You are there in both the cases, or the other case, Mr. GA?
First.
So there is no one from Mr. GA1's office or GA. I mean, there is a junior counsel, but he is not in a position to assist.
My lord. We have 5 minute counter, so your lordship can take up, my lord. In the next week, my lord, we will reply to the argument.
So the point which he has argued, and there are similar repetitions of the same petitioner admitted.
My lord.
With an interest protection. And the point which is argued, I don't know whether you have heard it or not. Have you heard of?
Yes, Lord. To some extent, I have heard it, Lord.
What he has argued?
To some extent, Lord, I have heard, and from the compilation.
No, he says that there is an amendment in the provision post that Tata Steel judgment, and eligibility under 18.4 is not in dispute to claim ITC. Whether he would be ineligible because of any of the conditions under 18.8, particularly 18.8.9. 18.8.9 is very clearly worded. ITC won't be allowed on interstate transfer or sale outside the state. The learned tribunal doesn't dispute that it is an intrastate stock transfer, but presumes that ultimately after intrastate stock transfer, if it there can, why should he get the benefit of ITC? This is not the case of the revenue also, that there is any sale outside the state. The assessing officer has denied it on the basis of the Tata Steel judgment. Tata Steel judgment was on the basis of a unamended provision of 18.8.9. That undertook a change because the legislature took note of the grievances of the businessmen who are operating within the state of Jharkhand. So they said that even though we are stock transferring inside the state or selling it within the state, still you are not allowing us the benefit of ITC because the wording of 18.8.9 is like that. Any interest rate in any stock transfer or any sale outside the state. So then this amendment was made in 18.8.9. And that amendment says that only interstate stock transfer or for sale outside the state will not be entitled for ITC in respect of goods consumed for manufacturing. So, and the other assessing officers, in case of other assessees and even the appellate authority, the revisional authority has taken a view which is being advanced by the petitioner. They are getting the benefit. They have cited few orders also. So, and he says that he has paid the differential tax also. So we can tag these two writ petitions with annexure 10, 3 writ petitions of the same petitioner concerning the same issue, which they related to which financial year, Mr. Garodia? Unmute.
Unmute, kindly unmute.
I'm sorry, my lord. Those were for some, my lord, unit 2, my lord. This is another unit that was on another unit. Financial years, my lord, after 2011 amendment. 11, 12, 12, 13, like that. We came straight away from the assessment orders in those cases.
Little appearance of both the parties. Heard, then counsel for the parties. petitions, both the writ petitions relate to the assessment year 2010-11 and 11-12. Stop. ITC on intrastate stock transfer has been denied to the petitioner. In both the cases, the assessing officer has relied upon the Tata Steel judgment.
Yes, my lord, both the cases.
The assessing officer in both the cases has relied upon the Tata Steel judgment rendered in WPT number 6285 of 2007, judgment dated
16/4/2008.
16th,
Sorry, pronounced on 24th April 2008.
24th April 2008. Stop. Page 63. Tata Steel judgment was rendered in respect of the unamended section 1889. Stop. Unamended section 1889 reads as under. Legislature effected an amendment in section 1889, which was initially through an ordinance by notification dated 7th May 2011. Stop. 1889 was amended with effect from 1st April 2006. Stop. The amended provision reads as under. Page 20, page 19 or 20, unamended. Stop. The appellate authority, the matter went up to the Commercial Taxes Tribunal. That the petitioner is covered under section 1884, section 18.4 is not disputed. Stop. Learned Tribunal has, however, interpreted the amended section 1889 in a manner that ITC won't be available to the SSE for the reason that in case of an intrastate transfer of stock, if ITC is claimed and allowed, the other unit of the petitioner will be at full liberty to subsequently make an interstate transfer of stock with no requirement to claim ITC as he has already availed the same through its Unit 2, which would be undoing the mandate of law under Section 1889 of the JVAT Act. That would defeat the legislative purpose. In protecting the interest of the state in recovering taxes. And the learned tribunal has further gone on to record, further recorded that there is, further observed that there is nothing on record to show that subsequent to intrastate transfer of stock, the goods were to be consumed for manufacturing purposes and or were sold within the state of Jharkhand. Stop. Learned counsel for the petitioner in the aforesaid background facts placed from the pleadings on record and the observations of the learned tribunal submitted that the learned tribunal has read something in section 1889 which is not there, and denied the claim of ITC in favor of the petitioner on a presumption that the SSC may at the end through its second unit possibly make an interstate sale. Stop. Learned counsel for the petitioner has submitted that this interpretation of the learned tribunal doesn't fit the scheme of the Act and the amended provision which the assessing authority, the revisional authority in other cases such as Annexure 11 in the case of, in other cases such as in the case of Messrs. Usha Martin Limited, Annexure 11, revision case number CC within bracket S 477 of 2019. Assessment order at Annexure 12 allowing such benefit of ITC to Messrs. Usha Martin Limited. And in respect of other registered dealers like Tata Steel Limited, Tata Motors Limited, have understood and followed in the correct lines, on the correct lines. Stop. It is submitted that petitioner has paid the differential tax pursuant to the assessment orders. But in case the impugned order of learned tribunal is not stayed, the same may have devastating effect as under section 42 of the JVAT Act 2005. The prescribed authorities may proceed to reassess tax payable by any dealer, even if such orders have become final. Stop. On same issue, the petitioner had approached this court in 3 writ petitions, WPT number 786 of 2013, 788 of 2013, 790 of 2018, to this court directly against the assessment order, in which the respondents have been restrained from taking any coercive steps by order dated 7th April 2013. Stop. It is prayed that the orders of the learned tribunal, impugned order of the learned tribunal may be stayed, pending final disposal of the writ petitions. Stop. Para. Respondents have filed a counter affidavit. Learned counsel for the respondent, AAG2, submits that counter affidavit has been filed yesterday only. Stop. दोनों का लिखिए, GA, AC to GA1 submits that the counter affidavits have been filed yesterday only. Stop. It is not disputed by them that the differential tax has been paid by the petitioner. Stop. On consideration of the submission of learned counsel for the parties, we are of the prima facie view that the impugned order of the learned tribunal deserves to be stayed, as the learned tribunal has proceeded to read something which is not there in section 1889 of the then bracket amended JVAT Act 2005. Stop. The assessing officer and the appellate authority had relied upon the judgment of this court in the case of Tata Steel, which at annexure 3,
Annexure 3, my lord, page 63.
which related to the unamended, which was rendered on the unamended provision of section 1889, where no input tax credit under subsection 1 would be allowed to a registered dealer within courts. Okay. In respect of goods used for manufacture of goods for transfer of stock or other than by way of sale or for sale outside the state of Jharkhand. उसके बाद एक sentence छोड़कर, provided that in respect of transactions falling under this clause, input tax may be allowed on the tax paid in excess of 4% on such materials used in the manufacture of the finished products. The amended section 1889 has been quoted above, which restricts ineligibility to claim ITC to a registered dealer in respect of goods consumed for manufacture of goods for interstate transfer of stock or for sale outside the state. इसको underline कर दीजिए. It is not the case of the revenue that there has been an interstate transfer of stock or sale outside the state. Stop. It is the case of the revenue also that it is an intra-state transfer of stock. Stop. As such, the impugned judgment of the learned tribunal is stayed. Date there is and doing judgment dated so passed by commissioner. Let the matter be tagged along with WPT number जो भी लिखे हैं 3 Annexure 10 stop and be listed under the appropriate heading for final disposal.
Milord, for date will fix Milord for hearing for final disposal.
In the month of April.
Any date, Milord?
In the first week of April 2020.
In the meantime, Milord, the pleadings will be complete, Milord. Complete by the parties.
Pleadings may be exchanged in the meantime. Between the parties may be exchanged in the meantime.
Much obliged.
IA number so and so seeking stay of proceedings is disposed of.
Item 24, WPT number 5430 of 2021. Mr. Deepak Kumar Singh for the
May it please your lordship. Your lordships are able to hear me and see me, my lords.
Yes, item 24.
Lordships, item 24, I appear along with my learned friend, my lords.
Yes.
Lordship, this is a petition, my lords, which essentially challenges the non-payment of GST, my lords.
Yes, who is appearing for the respondents?
Lordship, my senior Mr. P.S. This is appear in this matter. He's on Lexington and I've just informed him to join also.
Ask him to join.
Yes, your lordship.
Yes, then counsel.
May it please your lordships.
Yes.
There are two respondents before your lordships in the petition, lords. Respondent number 2 is the Commissioner of GST Kolkata, lords. And respondent number 1 is, my lords, Bain, Bharat Heavy Electricals, my lords. The issue in brief, my lords, is this, my lords, that I'm a manufacturer, my lords, of steel. And this steel is supplied by me to the respondent number 1 for export to Bangladesh. These are undisputed facts, my lords. These are undisputed facts. For export to Bangladesh, my lords. And since it is an export, my lords, there is a concessional rate for export of these goods, my lords. If your lordships kindly see that notification straight away for a minute, my lords. That notification is at annexure 4 of the petition, my lords. At running page 170, my lords.
170.
170, my lords. Running page 170.
Yes. Yes.
Has my lord got that?
Yes, yes.
Lordships. In the exercise of powers conferred by subsection 1 of section 6 of the IGST Act, the central government, on being satisfied that it is necessary in public interest so to do, on the recommendations of the council, hereby exempts the interstate supply of taxable goods by a registered supplier to a registered recipient for export from so much of the IGST that is leviable under section 5 of the IGST Act as in excess of amount calculated at the rate of 0.1%, subject to the fulfillment of the following conditions, namely, the registered supplier shall supply the goods to the registered recipient on a tax invoice. The registered recipient shall export the said goods within a period of 90 days from the date of issue of tax invoice by the registered supplier. The registered recipient shall indicate the GST identification number of the registered supplier and the tax invoice number issued by the registered supplier in respect of the said goods in the shipping bill or the bill of export. The registered recipient shall be registered with the Export Promotion Council or Commodity Board recognized by the Department of Commerce. The registered recipient shall place an order on the registered supplier for procuring goods at concessional rate, and a copy of the same shall also be provided to the jurisdictional tax officer of the registered supplier. The registered recipient shall move the said goods from the place of the registered supplier directly to the port, ICD, airport or land customs station from where the said goods are to be exported, or directly to a registered warehouse from where the said goods shall be moved to the port, ICD, airport or land customs station from where the said goods are to be exported. If the registered recipient intends to aggregate supplies from multiple registered suppliers and then export, the goods from each registered supplier shall move to a registered warehouse, and after aggregation, the registered recipient shall move the goods to the port, ICD, airport or the land customs station from where they shall be exported. In case of a situation referred to under condition 7, the registered recipient shall endorse receipt of the goods on the tax invoice and obtain acknowledgement of the receipt of the goods in the registered warehouse from the warehouse operator, and the endorsed tax invoice and the acknowledgement of the warehouse operator shall be provided to the registered supplier as well as the jurisdictional tax officer of such supplier. And when the goods have been exported, the registered recipient shall provide a copy of the shipping bill or the bill of export containing the GSTIN, that is the identification number, and the tax invoice of the registered supplier along with proof of general manifest or export report having been filed to the registered supplier as well as the jurisdictional tax officer of such supplier. The registered supplier shall not be eligible for the above mentioned exemption if the registered recipient fails to export the said goods within a period of 90 days from the date of issue of the tax invoice. Now, my lords may kindly note, my lords, this is part of my submission. I read out the entire notification, my lords. The entire notification is an exemption granted, my lords, in essence, to the recipient of the goods. And all the conditions need to be satisfied by the receiver of the goods, my lords. And therefore, the exemption is granted qua those goods. The exemption is granted qua those very goods, my lords, which are to be received by the registered recipient for the purpose of export, my lords. And it is his duty to undertake all these functions, my lords. All these conditions are qua that, my lords. And in my respectful submission, my lords, and in favor of the respondents also, my lords, all these conditions have been met. There is no dispute that all these conditions have not been met. However, the dispute lies here, my lords. The dispute lies here, my lords. If your lordship sees para 2 of the notification, para 2 of the notification says that this shall be exported within a period of 90 days. Now respondent number 1, my lords, admittedly could not export it within a period of 90 days from the date of the invoice. And I'll tell your lordships in favor of respondents also. The reason was there was a technical issue at the customs port, my lords, wherein the EDI system was being implemented and there were COVID restrictions, my lords. During this period, there were COVID restrictions, and for that reason, he could not export within 90 days. But export is not under doubt, my lords. He has exported. The shipping bills are on record, and copies of the shipping bills have been submitted to the respondent number 2 also. That is also not in dispute. The only issue lies is, since you have not exported within 90 days, for whatever reason, you are not eligible, and therefore a demand is being made against me, the petitioner before your lordship, saying that you please pay the differential tax along with interest and penalties. Now, my lords, I have a twofold submission, my lords. I have a twofold submission for my lords' kind consideration, my lords. Lordships, here is a recipient and here is a respondent number 2, my lords, both being government, my lords. I, as a supplier, my lords, in terms of the notification, have no role. My limited role is to supply these goods pursuant to a purchase order, which admittedly I have done, which has been admittedly exported by respondent number 1. Now, my lords, I have placed on record several communications and correspondences by respondent number 1 to respondent number 2 seeking relaxation of that condition, saying that we could not export within 90 days because the government came out with a circular. The government itself came out with a circular saying that, sir, we understand this 90 days can sometimes be an issue. Therefore, you make an application to the commissioner saying that you could not export in 90 days for whatever reason. He shall examine that independently on the basis of the facts of each case. I cite that circular also, but there is no response by respondent number 2 to the applications made by respondent number 1, my lords. And he straight away starts recovery action against me. He doesn't respond to any of the communication from respondent number 1. He doesn't respond to any of the communication from me. He starts a recovery action against me, my lords. And I must point out, my lords, during the pendency of the petition, my lords, if your lordship sees the recovery notice, there was a total demand, my lords, of about 13.5 crores, my lords, on this exports, my lords. Kindly appreciate the position of the petitioner, my lords, where I have exported the goods. We earn valuable foreign exchange for the country. And there is a demand of about 13.5 crores. And during the pendency of the petition, they have recovered, my lords, 11.27 crores already. They've already recovered 11.27 crores. Therefore, my limited submission today for my lords' kind consideration would be, lordships may issue notice to them, invite a counter, my lords, and in the meantime, this differential may be stayed, my lords. Because according to me, that is also not the liability. The correct liability, my lords, even if it were there, it will be around 10 crores, my lords. I have paid much more. And therefore, this is an issue which your lordship need to examine, my lords.
This annexure 16 summons was issued upon you. Yes.
Lordship serial number?
Annexure 16 at page 197.
That's me, my lords. They threatened me, my lords. They called my CFO and said, unless you pay, I will not let you go.
No, so you appeared on the summons.
Yes, my lords, I appeared, and then they said, unless you make the payment.
So these documents were produced by you?
Yes, my lords. All this was produced. I made an averment in the petition, my lords. And I'm sure my learned friend cannot deny that, my lords. Lordships, may kindly have annexure 18, my lords.
Yes.
Kindly have annexure 18. This is the total demand that they called upon me to pay, my lords. Via the above mentioned letters, it has been requested to pay differential tax of rupees 13.26 crores, which has arisen out of failure to export the goods by Messrs. Bail within the stipulated period of 90 days as stipulated notification 41 of 2017. However, even after lapse of substantial period, the same has not been complied till date. Further, it was also requested to provide remaining proof of export details relating to remaining invoices while the goods were supplied at concession rate to BAIL. But the same has not been provided to date. Moreover, the reconciliation of ITC as reflected in GSTR 3B and 2A has not been provided. Hence, it is requested to pay differential tax of 13 crores. And my lords, I must show there are communications from respondent number 1 to the very same commissioner, the very same respondent number 2, seeking a relaxation or an extension. Lords, you may kindly see one illustrative, my lords. I'll just show that. If your lordship kindly has, my lords, annexure 10, my lords. Annexure 10 at running page 186, my lords. My apology, my lords. At running page 186, annexure 10, my lords. And these supplies are against a government treaty between India and Bangladesh, my lords. Your lordships have page 186, my lords.
Yes.
They have written to them in July also, my lords. Then this is a letter again in August, my lords. Request for extension of export obligation period, Rule 96A1A of the Cgst Rules and circular of the board dated 15th of March 2018. And lords may kindly see the last para in that or page 187, my lords. Last para, my lords. In view of the above, by the enclosed letter of 23/9/2019 and 29/1/2021, we requested to grant extension of the time limit for export obligation till 30th of September for executing the export of the above mentioned consignments in line with circular of the board dated 15th of March and thereafter visited the HQ technical section several times. And we were informed that a positive report from the division has been obtained regarding this. An extension is deemed to be granted. Accordingly, we understand the extension is deemed to be granted. The same was submitted to your good office again on 27th of July 2019. Hence, we again requested to consider granting extension of time limit for export on post facto basis in line with clause number 5 of circular dated 15th of March 2018, my lords. And the same representation I make to the respondent number 2, my lords.
What was the period of the supply and the time limit when it was to be exported within 90 days?
Actually, these are exports during 2019, my lords, subject to correction, my lords. Just 1 second, my lords.
This was before COVID period.
This is pre-COVID, my lords, but there are subsequent supplies also, my lords, which ought to have ended by February or March of 2020, my lords. Yes, part of it is pre-COVID. Your lords are absolutely right, my lords. But the board clarified that this relaxation can be granted if your lordships kindly have that para 5 of that circular. I have quoted in the petition, my lords. At running page, my lords, 188. At running page 188 is my representation to respondent number 1. Saying that you please consider the respondent number 1's application. And there I have quoted, my lords, I have made a detailed representation. If your lordships kindly come directly to page 190, my lords, running page 190. Has my lords running page 190, my lords? Lordships may kindly have para 5.
Yes.
Para 5. Since the extension request by BAIL is intricately connected to our claim for exemption in terms of notification 41, we most humbly request that the same may be kindly granted. In this regard, reference is invited to para 5.1 of circular of 2018 dated 15th of March 2018, which empowers the jurisdictional commissioner to grant extension of time limit for export on post facto basis, keeping in view the facts and circumstances of each case. Para 5.1. It has been reported that exporters have been asked to pay integrated tax when the goods have been exported but not within 3 months from the date of issue of the invoice for export. In this regard, it is emphasized that exports have been zero rated under IGST Act, and as long as goods have actually been exported, even after the period of 3 months, payment of IGST first and claiming refund at a subsequent date should not be insisted upon. The board clarified, Lordships. In such cases, the jurisdictional commissioner may consider granting extension of time limit for export as provided in the said sub-rule on post facto basis, keeping in view the facts and circumstances of each case. The same principle should be followed in the case of export of services. This is for the reason, Lordship, the intention is not to tax exports. The intention is to export goods and services, not the taxes, my lords. And this is my representation, which remains unanswered, and they start recovery action against me, my lords. The very same respondent number 2, either he has to accept my application or reject my application, my lords. Then I make a representation to respondent number 1. They also say you go and deal with respondent number 2, my lords. I am being ping-ponged between both the arms of the state, my lords. Therefore, this matter, my lords, in my respectful submission, requires your lordship's consideration, my lords.
Finally, the exports were made.
Yes, my lords. All the exports have been made, my lords. That is not in dispute, my lords. If your lordships kindly see. They themselves admit in their letter itself that there is an export, but it is delayed. The respondent number 2 in their letter itself admits, my lord. That there were exports where proof was submitted within 90 days. There were exports where proof was submitted beyond 90 days, my lords.
My lord, it is mentioned page 192 at annexure 12, my lord, in their letter, my lord.
Yes, I am grateful to my learned friend, my lords. Thereafter, all the details have been provided, my lords. That is again reiterated, my lords. My apology. My apology. My apology.
Where is the council?
Lordships.
Respondent number 2.
Lordship, my senior is on legs. Court number 10, court number 1, your lordship, some Passover matter is going on. So, your lordship, I'm just praying for 4 weeks time to file a counter in this because we have to give a reply to this.
Where have you stated that you have made deposit of 11 crores and all?
Lordship, this is a letter received by me on 18th of February, my lords. I'll just share, my lords. I'll ask my learned friend to share the screen. We have received it on 18th of February, this letter, my lords, which records this fact, my lords. I'll just screen share it, my lords. Omkar, if you can just show the screen. Your lordships are able to see this letter, my lords, of 18th of February, my lords. Lordship, this is from respondent number 2. Kindly have para 2, my lords. Para 2 of this letter. You have paid an amount, amounting to rupees 11.27 crore only against the liability of 13.26 crore arising out of non-fulfillment of the condition laid down in notification 41. Hence, you are requested to pay the remaining tax of 1.99 crore at the earliest. And then they calculate interest also at the last para, my lords. In the last para, they are saying please pay interest also 5 crores. Lordships may kindly have the last para in this letter also. You are also requested to pay 5.12 crores towards interest on differential amount of tax of rupees 11.27 crore, which has been paid against supplied to Mrs. Bale, Kolkata, at concessional rate of 1% for export along with penalty at the rate of 15%, and they give the calculation also. You are requested to pay this within 5 days, failing which recovery action as per section 7512 of the Cgst Act.
Yes.
Lordships, I have paid much more. And this is also not payable, my lords. It's in case of an export. Therefore, this differential, my lords, till the time they file the reply, my lords, has to be kept in abeyance, my lords. This recovery action cannot lie, my lords. That's my respectful submission for my lord's kind consideration, my lords.
In case the exemption is not admissible to you because of the delay in the export, then respondent number 1 is supposed to reimburse the tax that you have.
Yes, my lords, yes. The entire tax is supposed to be paid by him to the government directly, my lords. That's what I showed your notification that I have no role to play in this, my lords. The entire condition of the notification has to be satisfied by the receiver, my lords. This is an exemption granted to the receiver because he has an agreement with the state of Bangladesh, my lords, where he has to supply these goods, my lords. And, my lords, in this, my lords, I have ended up paying 11.27 crores, my lords. I have not received it from respondent number 1, my lords. I am making a statement. I have not received it from respondent number 1, my lords.
Clause 5B of the tender.
Lordships, I am obliged, my lords. If your lordship sees clause 5B at page 124, my lords. The terms and conditions of the tender, my lords. Specifically, they note at running page 124, my lords. And then they again reiterate in the purchase order as well. I'll just show both of that, my lords. At running page 124, has my lord got that?
Yes.
Lordships may kindly see taxes, duties, Indian GST for Indian suppliers.
Yes.
14.1.1 says all taxes excluding GST along with cess but including charges, royalties, any state or central levy and other taxes for materials, if any, obtained for the work and for execution of the contract shall be borne by the successful supplier and shall not be payable extra by bail. Then notice may have 14.1.2. GST along with cess as applicable, legally leviable and payable by the successful supplier as per GST law shall be paid by bail extra. Hence, that is bold, my lords, kindly note it is bold condition. Hence, supplier shall not include GST along with cess as applicable in their quoted rates price. I paid from my own pocket. Supplier, however, must ensure that the reduced concessional rate of GST is applicable for the penultimate exporter. While notification 41 of 2017 or similar notification issued by the state or the union territory GST authority is levied along with all necessary compliances. The documents undertaking required for availing concessional rate of GST shall be made available by bail to the supplier before, during or after export of goods from India. And same thing, my lords, they reiterate in the purchase order also. Clearly, again reiterating, my lords, the purchase order, my lords, starts at running page 145, my lords. 144, my lords, my apology. 144.
Yes.
Has, my lord, got page 144, my lords?
Yes.
Kindly have, my lords, in that breakup, my lords, reinforcement steel, reinforcement steel, reinforcement steel, reinforcement steel. There are different grades, my lords. And then lords may kindly note other charges, packing, forwarding, handling, etc., etc. And then column 4, last, my lords, all inclusive FOB port price, including all taxes and duties, excluding Indian GST. And then there is an asterisk, my lord. There is an asterisk down just below that. GST along with cess as applicable, legally leviable and payable by successful bidder as per GST law shall be paid by bail. And I am out of pocket, my lords. I did not even make this much income in the contract, my lords, which GST I have been asked to pay, my lords. And there is recovery action against me, my lords. Therefore, my lords, I am before your lordship with folded hands, my lords. That this issue needs to be decided by your lordships, my lords. And in the meantime, this recovery action should be stayed, my lords.
Can you indicate what was the period of your supply?
Period of my supply, lordships.
For which this demand has been levied against you?
Because the order was placed in January and September of 2019, my lords.
Your lordship is there in the letter, if I may interject, there is there in the letter, it says 2017-18 to 2020-21.
In that demand?
Lordship, in the demand letter at running page 192, my lords. If your lordships kindly have page 192, as well as, my lords, again it is reiterated at running page 198, my lords. Lordship, the period is 18, 19, 19, 20, 20, 21.
Very good.
18 to 21, 21 to 22.
21 to 22.
There is a breakup also in the very same letter, lordships.
You send this letter to the court master through mail or towards.
I'll ask the AOR, my lords.
We will do it. We'll do it, Your Lordships.
Please send your appearance slips.
Lordship, I'll ask the AOR.
You are Mr. Bharat.
Lordships. Bharat Rai Chandani, Lordships.
You are addressing us from Mumbai or?
Lords, I am at Mumbai, my lords. And I hope, my lords, that I get a chance to appear physically before your lords, subject to my lords.
Let's see. Petitioner has made supplies for export to respondent number 1, BHEL. Stop. The notification number 41/2017 dash integrated tax rate dated 23rd October 2017 issued by the Department of Revenue, Ministry of Finance, Government of India, grants and exemption in interstate supply of taxable goods by a registered supplier to a registered recipient for export as in excess of amount calculated at the rate of 0.1%, subject to fulfillment of the laid down conditions therein, Annexure 4. Respondent number 1 couldn't make the export within the time limit of 90 days as required under subclause 2 of the exemption notification. Stop. Under the terms of tender, Annexure 1, Clause 14, (14.1.2), GST along with cess within bracket as applicable, legally leviable and payable by a successful supplier as per GST law shall be paid by BHEL, extra. Stop. Hence, supplier shall not include GST along with cess within bracket as applicable in their quoted rates price. Supplier, however, was under an obligation to ensure that the reduced concessional rate of GST as applicable for penultimate exporter by notification dated 23rd October 2017 or similar notification issued by the state shall union territory GST authority is levied along with all necessary compliances. As per the purchase order, annexure at page 144, as per one of the purchase order at page 144, all items, all inclusive, the items rate are all inclusive total FOB port price, including all taxes and duties excluding GST. Stop. GST along with cess within bracket as applicable, legally leviable and payable by successful bidder as per GST law shall be paid by BHEL. Stop. Petitioner, supplier, responded with the Commissioner, North CGST and Central Excise Commissionerate, Kolkata, within bracket annexure 11, with a request for extension of time limit for making exports by BHEL during the period February 2019 to April 2020, and specifically referred to para 5.1 of circular number 37/11/2018-GST dated 15th March 2018, as per which if in cases the export have been made but not within 3 months from the date of issue of the invoice for export, payment of integrated tax first and claiming refund at a subsequent date should not be insisted upon. Stop. Then counsel for the petitioner submits that the circular clause 5.91 of the circular indicates that in such cases jurisdictional commissioner may consider granting extension of time limit for export as provided in the said sub-rule on post facto basis, keeping in view the facts and circumstances of each case. Stop. The same principle should be followed in case of export of services. According to the petitioner, this representation remained unresponded and petitioner received a notice. Such a request was also made by the recipient Bhel by the annexure 10 on 19th August 2021, citing delay in exports due to implementation of EDI system for the first time in a riverine route in the month of June 2019. Stop. It caused consequential cascading delays which were lined up serially to the other barges. Stop. However, petitioner received summons to produce certain documents on 18th August 2021. However, petitioner was asked to make pay the differential amount amounting to rupees 9,41,49,267.71 as differential tax liable to be paid for the supplies made in the respective years 2018-19, 2019-20, 2020-21. Petitioner was also asked to produce certain documents by summons dated 12th August 2021. पहले वाले को annexure 12 कर दीजिए, दूसरा अभी जो लिखा है annexure 13 and 14. 13 to 16. Sorry, 13, 14 and 16. Stop. Similar notice for non-payment of tax amounting to rupees 3 crore 85 lakhs 322 for the same periods with the details of invoices were issued on 17 September 2021. Followed by the letter dated 29 September 2021 asking the petitioner to pay the differential amount of tax of rupees 13 crores 26 lakhs 49,589 and submit copy of DRC 03 for the same. Petitioner was also asked to submit copies of proof of exports, shipping bills of remaining invoices as communicated by letter number 5717 dated 17 September 21 for urgently for calculation of tax liability, if any, along with reconciliation statement of ITC. Stop. These materials have been placed from the record by learned counsel for the petitioner and the copy of the letter bearing number 1042 dated 21st February 2022 issued by the Deputy Commissioner within bracket Prevention, CGST and Central Excise Ranchi has also been sent through mail, WhatsApp, which is being taken on record. Learned counsel for the petitioner has pointed out from the letter dated 21st February 2022 that the payment of rupees 11.27 crore against the liability of rupees 13.26 crore has been acknowledged by the department. Stop. However, the respondent number 2 has respondent number 2 has also requested to pay rupees 5 crore 12 lakh 71,194 towards interest on differential tax amount of rupees 11.27 crore, which has been paid against supply to Messrs. Bhel, Kolkata at concessional rate of tax at the rate of 0.1% for export along with penalty at the rate of 15%, failing which recovery under section 79 of CGST and Central Excise will be initiated against it as per section 75(12) of the CGST Act 2017. Stop. Learned counsel for the petitioner in these background facts has argued that because of delay in export by the respondent number 1, petitioner is being made liable to pay the differential tax, though all the compliances were required to be made by respondent number 1, Dhale, the recipient. Stop. Respondent number 1 under terms of the tender, respondent number 1 being a state entity under the terms of the tender and also the purchase order, is required to pay the GST leviable and payable by the supplier. Stop. Respondent number 1 has, however, surprisingly denied to compensate the petitioner with the additional IGST liability by its letter dated 2nd November 2021 within bracket annexure 22. Respondent number 2, instead of making the respondent number 1 recipient liable for the payment of the additional IGST, has instead raised the demand of rupees 13.26 crores against the petitioner, and on threat of coercion petitioner has been made to pay an amount of rupees 11.27 crore only, 27 crores, leaving the balance tax amount of rupees 1.99 crore to be paid. Stop. In these background facts, learn counsel for in these background facts and based on the relevant materials on record, learn counsel for the petitioner has prayed for an interim protection from any further coercive steps being taken against the petitioner pending adjudication of this dispute. Stop. He contends that both respondent number 1 and 2 are state authorities and the dispute is amenable to writ jurisdiction. Learn counsel for the CGST, Mr. Pati, appear here.
Yes, my lord, I am here, my lord.
Mr. Pati, you respond. Meanwhile,
only one short submission, my lord. The entire prayer in the writ petition is directed against respondent number 1, and they are seeking a recovery action of the respondent number 2. Lord, may kindly see the prayer that they have made.
You are a necessary party.
Yes, but they are seeking stay on my recovery action.
They do not deny that because of failing to comply the timelines, the exemption cannot be availed unless accepted by the tax authority. But they say that as per the terms of tender and purchase order, respondent number 1 is supposed to pay it back.
It is a contractual relation between them, my lord.
Contractual relationship.
Petitioner and respondent number 1.
So you have not proceeded to realize it from respondent number 1, but demanded it from petitioner.
And that demand has not been challenged by them even.
No, So meanwhile, they have deposited about 11.27 crores. You don't take any further coercive steps. Let the parties appear and file their response.
May I submit, my lord? We have also filed an IA application for stay, my lord. That is on board, my lord. Against the demand.
Beyond the red prayers in the red petition, some another prayer cannot be made.
Yes, by way of IA application, we have prayed before, my lord. That is IA number 155 of 2022.
Yes, that IA is there.
Yes, my lord.
Copy has also been served upon Mr. Pati. Stop. Then counsel for the respondent number 2, Mr. P.S. Pati, prays for how much time?
Since your lordship is staying the further proceeding 3 weeks, I'll do it within 3 weeks, my lord.
3 weeks time.
But any date after 3 weeks may be fixed, I'll do it in the meanwhile. I'll file the response.
Affidavit. Stop. 1 week time thereafter is allowed to the petitioner to file reply so advised. Let notice issue on respondent number 1 under registered cover and speed post, for which requisites be filed by Friday. Stop. Let notice be additionally effected by the petitioner upon the official email address of the respondent number 1, containing the attachment of the entire pleadings and its enclosures by Friday, and a supplementary affidavit to that effect be filed in the next week. Stop. Let the matter appear on March 31, 2022. In the meantime, no coercive steps be taken against the petitioner. No further coercive. No further coercive steps be taken against the petitioner.
Only my 2 submissions you only indicated in the order sheet. My submission have been.
One submission I could gather. The next one?
But first I had said that the recovery action has been not challenged and the entire writ petition, the prayer is directed against payment of the tax by the respondent number 1. That is, and the second, that the reference being made to the other documents, those are documents inter se the petitioner and the respondent number 1. I am not a party to those on contract or any document.
Then counsel for the petitioner, respondent number 2 submits that that the grievances of the petitioner are essentially directed against the petitioner number 1.
Respondent number 1.
Sorry, respondent number 1. Stop. However, the second submission is not correct because they have challenged.
I believe, my lord, in the writ petition, they have simply said that the direction for respondent number 1 to pay. Don't deny the liability, don't say it is incorrect. Respondent 1 be directed to pay the entire amount.
There is a prayer in the IA upon respondent number 2.
And if I may just
clarify the prayer in the writ petition, they are not seeking an amendment of the writ petition.
We have not perhaps read the interlocutory application for stay.
Hello.
That's all. Yes.
Grateful. We are obliged, my lord. Indeed obliged.
Your Lordship, may I just be allowed to mention a case, Your Lordship, that is the
With my
next.
lord's permission, my lords, may we log off, my lords?
Yes, sure.
Grateful. We are obliged, my lords.
May I be allowed to mention about the next case, Your Lordship?
Yes.
The next case, Your Lordship, is WPC 1336 of 2013, item number 25.
Yes.
In this case, Your Lordship, I was only praying 1 or 2 days accommodation in this case. It may be adjourned, Your Lordship.
लास्ट डेट पे नो फर्दर एडजर्नमेंट का ऑर्डर है हुजूर.
You are praying for what reason?
For the reason, Your Lordship, that some letters have come from the Union of India with regards to our appearances in the railway cases.
So you will be appearing or you may not be appearing now?
No, Your Lordship, I will appear, but I will have to talk with the officer, Your Lordship.
List it on next Wednesday.
Yes, Your Lordship.
Mr. Mahesh Tiwari, Learned Counsel for the petitioner, admits that there has been some rearrangement in the panel of appearing for railways. Therefore, the matter may be adjourned for short time. So as to receive specific instructions. And that, as such, matter is passed over for the.
We are obliged.
Lord, may I be permitted to mention one matter, my lord? Serial number 15. Lord, 15 was not called, my lord.
15 has gone before another bench because brother will not be able to hear it. They have passed an order.
Lord, the matter will not be taken today.
No, Brother Justice Roshan will not hear this matter because in the earlier litigation he might have appeared. He has appeared for some.
Yeah, yes, he has appeared in the identical matter.
Yes. So, very
My
well.
lord, may I mention serial 16, my lord, passed over matter, my lords. My
Yes.
lords, actually I have a part heard matter right at 2:30, my lords, before court number 1, my lords. So I was praying that it may come tomorrow or any other day, my lords, as per my lord's convenience.
So I have no objection to such a request being made, but the only thing is that my ITC has been blocked. My electronic credit ledger has been blocked.
That, my lords,
It's
we
been
have
2 years.
my lords, that we are in the process of unblocking their ITC, my lords, their electronic ledger, my lords. We have filed a supplementary to that effect, my lords.
Let it be on next Wednesday or Thursday then.
So let it be on Wednesday, my lords.
Wednesday.
Much obliged.
Much obliged.
और क्लिक कर लीजिएगा मैसेज भी है इनको अभी